Hi, Victoria. So I decided to just go ahead and basically make my own video to kind of teach you the first couple things that I want you to learn about. So this video is going to be about something called consular processing, and that is the process that we use to get people green cards when they either are outside the United States or for other reasons they're not eligible to get their green card inside the United States. So before I get started, obviously you know that a U.S. citizen is someone who was either born in the United States or someone who applied for what we call naturalization, making them a United States citizen. And then the other term that you need to know is what we call a lawful permanent resident, or sometimes we call them an LPR, or sometimes a green card holder, because the card that they get is actually kind of green colored. And so green card holders are kind of like one step down from US citizens. There's some things that US citizens can do that they can't, like US citizens can vote, and there's certain security clearances that green card holders can't have. But other than that, a green card holder is just someone who has a lawful right to live in the United States. And the important thing is that they can also bring certain family members with them. So a consular processing is the process that we use to get someone a green card when they don't qualify to get their green card here in the United States. The process of getting it here in the United States is called adjustment of status, but we do a lot more consular processing cases, so I thought I'd start talking about that. And this is actually something that we did when I worked at the U.S. consulate way back when in Rio. We would have people come and be interviewed up on the second floor to get their green card or to qualify for lawful permanent residence. But it happens for the most in our practice because most of our clients are from Mexico. It happens most often at the U.S. consulate in Juarez, which is right across the border in Mexico from El Paso in the United States. So I want to start by explaining that the whole consular process part of getting a green card has basically 4 steps in it. For people who are living in the United States illegally, like meaning they entered without a visa, there's 4 steps. For someone who has had no problems with immigration whatsoever, maybe they've lived in their country their whole lives, there's only 3 steps. But most of our cases involve all 4 of these steps. So the first step is called an immigrant visa petition, and the form is called an I-130. And so a lot of times you'll hear people talking about I-130 when they mean the immigrant visa petition, but it's just so common that we sometimes just refer to it by its name. And so I think the most important question is who can qualify, like who can benefit from an I-130. So in an I-130, you have 2 people. You have the petitioner, that's the U.S. citizen generally, and then you have the beneficiary, and that's the person who's getting the green card. So most of the time, it's husband and wife. So like let's just say the wife is the U.S. citizen and she's filing the petition on behalf of her husband, who's not a citizen, who's the beneficiary. Sometimes it can also be parents and children. So the child is a U.S. citizen over 21, and they're filing for their parent who's going to be the beneficiary. And occasionally you have a U.S. citizen parent who's filing for their child. Maybe, for example, if the U.S. citizen is living in a foreign country and they have a baby while they're there, there's a couple different ways for that child to get legal status in the United States, but one of them is to file a petition. So generally, all that you need when you're filing an I-130 is proof of identity. So that's like birth certificate, passport, something that proves who you are. And then proof of the relationship between the petitioner and the beneficiary. So if it's a marriage case, you're going to need proof that it's a genuine marriage, that they didn't get married just for the immigration benefit. And so we call that a bona fide marriage, and we talk about bona fide marriage evidence. And what that means is documents that show that these people have a real relationship. It could be phone bills, car insurance, life insurance, pictures, letters, basically anything. Like there's no specific list. Children, the children's birth certificates. When we have a case of a child filing for a parent, an adult child filing for a parent, or that adult is filing for their child, there we're just looking for proof of relationship, and that's usually just a birth certificate, sometimes marriage certificate and birth certificate, but that's pretty easy. And so in order to get the petition approved, it's pretty straightforward. You just have to show that there is a bona fide relationship between the petitioner and the beneficiary, and that the petitioner is a U.S. citizen. So for spouses, husband and wife, it doesn't matter the age of the petitioner. The petitioner could be 15 if that's a legal marriage in their country, or they could be 95 if that's a legal marriage in their country. The age does not matter at all. For children filing for their parents, the child has to be at least 21 before they can file on behalf of their parent. And then for this one, for the parent filing for their kid, until the kid is 21, it's a pretty straightforward process. So that is the standard for the I-130 petition. Once we file it and we mail it to USCIS, which is the agency in charge of immigration, most immigration in the United States, it takes about 6 to 9 months to get approved. So first we send it, and then we wait for it to get approved. And then once it's approved, we move on to the next step. So for someone here in the United States who entered illegally, that person would need a waiver due to their illegal entry. There's also about 9 or 10 other things that can cause someone to need a waiver. And I'm not going to actually talk about that today. I'm just going to kind of limit this conversation to the situation where someone entered the United States illegally. Now they need a waiver. And so for this, when they just need a waiver for this one particular thing, just because they came illegally, so like no criminal history, no past deportations, like nothing like that, we call this a provisional waiver. And it's sort of a long and kind of boring reason why, but it's just a specific waiver for this one situation called the provisional waiver. It comes on a form called I-601A. And if the person needs any other kind of waiver, it's called an I-601. But this one limited situation, it's called an I-601A. And in order to get the waiver approved, we have to show that the beneficiary, this person over here, is going to, sorry, I said that wrong. We have to show that the petitioner, the U.S. citizen over here, is going to suffer extreme hardship if the beneficiary is not allowed to get their green card. Okay? And so that can be, we do everything we can to show all different kinds of hardship. We talk about economic hardship, financial hardship, it's kind of the same thing, education hardship, medical hardship, psychological hardship. But the idea when we do the waiver is to show the really strong bond between the petitioner and the beneficiary and why the petitioner needs the beneficiary to stay here. Okay, so when we do this waiver with our clients, we will interview them, we'll have them write letters, we'll collect evidence. By the time we're done, the waiver is usually about like this thick, and it's just all this documentation to show immigration why our petitioner needs the beneficiary to stay. Now, the one thing that's kind of weird about the waiver is that spouses are qualifying relatives for the waiver. So if I am the beneficiary, I need to have a spouse who's a U.S. citizen. They can qualify for me to get the waiver. But children do not qualify. So, for example, if it's going to cause extreme hardship to the beneficiary's children, that is completely irrelevant. Like that does not have anything to do with the waiver. The waiver, they don't care. When they're making their decision, they don't care about hardship to children. Now, sometimes we argue that if the petitioner and the beneficiary have children together, if the petitioner's children are suffering, that's going to cause hardship on the petitioner. And when the petitioner is suffering hardship because the beneficiary is gone, that does count. So Imagine for a minute the beneficiary leaves. Now the beneficiary's children are sad, depressed, stressed, getting bad grades in school, whatever, because their dad is now gone. That creates hardship for the mom in this case, and that's something we can talk about in the waiver. The time when this qualifying relative thing really comes into play is if we have a child filing for their parent and the parent needs a waiver. This child cannot be a qualifying relative for the waiver because children don't qualify. This parent up here has to have a spouse who's a U.S. citizen or a green card holder, and we talk about that hardship in the waiver. So the point here to understand is that if someone entered the United States illegally, they're going to have to file this waiver. And the waiver is a lot of work. It's really complicated. And because of the way the law works, we cannot talk about hardship to just any relative. There's only specific relatives that qualify. So once the petition and the waiver have been approved, then the whole thing gets sent to what's called the National Visa Center. And the National Visa Center is kind of a clearinghouse for all the embassies and consulates all over the world. And so they take the case and they require that we send them two big things. One is a list of civil documents: birth certificate, marriage certificate, divorce decree, criminal history, taxes, proof of income, proof of medical insurance. Those are all the documents that we have to send. And at the same time, there's an online questionnaire called the DS-260. That's that form name. And that questionnaire asks everywhere that the person has lived, worked in the last, sometimes since they were 16, names of family members, immigration questions, security questions. It's like 10 pages of questions. So we have the petition approved, we have the waiver approved. Now we're doing the list of documents, the civil documents, and the DS-260. Once we get both of those complete, the National Visa Center, which we call the NVC, notifies us that they have everything complete and our client is just waiting in line for their turn for the interview. Sometimes once they have everything complete, they wait in line for 3 months for their interview. For a while in Mexico, people were waiting up to a year for their interview just because of the number of people waiting. It completely depends on how many people are in that country and are wanting to be interviewed. And of course, COVID is going to slow it way down because for months they weren't interviewing people. So there's probably like a 4 to 5 month backlog at the consulate. So we get eventually, so the National Visa Center says, okay, your client is in line for their interview. And then a few months later, we get a letter that says, here's the date and time of their interview. So 9 times out of 10, that client is here in the United States. And in order to go to their interview, they have to leave the United States, go back to their home country. So for people from Mexico, this is not a big deal at all because the U.S. consulate in Juarez is like a mile away from the border. For people in other countries, obviously, it's a much bigger deal because they have to arrange a trip home. And the reality is that most of these people that we're doing this for, they have lived in the United States for 5 years, 10 years, 20 years, and they're all really, really nervous about going home because things have changed. But I guess more specifically, they're worried that they might not be able to come back. And so this is a totally valid concern. If there's any important information or past problems with immigration that we missed, they could legitimately not be able to come back, and that would be a huge deal. So it's really, really important that they are honest with us from the beginning, because the minute they cross the border, this is kind of like the big moment of truth, right? So usually 3 days or so before the interview, they'll leave the United States. Once they get to their country, there is a fingerprint exam that they have to do. Sometimes they do that at the interview. In other countries, they do it a couple days before the interview. There's a medical exam that they have to do to make sure they don't have certain contagious medical conditions. And then there's the interview itself. And every country is a little bit different. We hear the most about Juarez because that's where most of our clients go. But essentially, from what I understand, people kind of like wait in line and then they just go They just go from like stage to stage to stage until their interview is complete. If they pass everything, so if everything goes well, they are basically the person takes their passport and they give them a note that says like, you're going to get your visa. We will send it to you in a couple days via a courier like FedEx, DHL, something like that. If they don't pass, if there's like a question or a problem, they get this blue piece of paper that has a box checked which explains like what the problem is. Sometimes most of the time, that blue paper means they need to do another waiver, that there was some kind of problem with the first waiver, and so now they need to do another waiver. And the waiver is not that hard. I think in all my time practicing law, I've always gotten the waivers approved. But the bad thing is that the waiver currently takes about 15 months to get processed. So that's someone who was living here in the US with their wife and kids. They thought they were taking like a week or two off of work to go get their visa, and now they're going to be in Mexico or wherever for the next year and a half. So obviously we do everything we can to avoid that, but it's usually only a problem if there's something that the client didn't tell us about. So assuming the interview goes well, they wait a couple days. The consulate prints the visa and the passport. They mail it back to the person, to the client. And then once they get their visa and their passport, that means that they're cleared to come back into the United States. So they can walk across the border in Juarez or they can fly, either one. They are not technically green card holders or lawful permanent residents until they enter the United States. But then once they enter, they are U.S. Lawful permanent residents, and they can live here as long as they want. I would just add that it's my job as the lawyer to screen for issues that could cause problems as we go. And I always talk to people in our very first meeting. I talk to them about all the different things that could potentially be a problem. Some of the obvious ones are like past deportations, criminal history, but also there's some kind of trickier ones, like if the person has tattoos that the consulate might think is a gang tattoo, that can be a big problem. If the person has maybe previously, like the first time they came to the United States illegally, if they brought a young child with them, usually it's their own child, and no normal person would consider that human trafficking, but sometimes the consulate considers it human trafficking. And then just other things like having been stopped by immigration, previous deportations, things like that. So I always screen for all of those things in our very first meeting. But the reality is that sometimes people don't remember everything, or sometimes they are afraid to tell me, or maybe they're not afraid, but they think nobody knows about it. Also, I forgot to add, there's a drug test when they do the medical exam. So it's important that they're not taking drugs, which seems pretty obvious, but some people do. So those are the fears. And then I get a lot of questions about things like, I once did something that I probably shouldn't have done, but I don't think anybody knows, but I don't know if they're going to know at the consulate, and what do I do? And so my only advice to you, I guess, is that when you're talking to people, if you hear them kind of like everybody's kind of like regular level nervous, but over time you'll notice that some people are like extra nervous. When they're extra nervous, I usually think that's because they're worried about something or they're hiding something and they're not really sure what it means. So sometimes I'll just tell them like, hey, I don't know of anything in your case that's going to cause a problem, but if there's anything that you're worried about, this is the time to this is the time to tell me, because once you leave and cross the border, it's too late. So this is like consular processing in a 20-minute nutshell. And then tomorrow we can talk, or in the morning, we can talk about any questions that you might have. Thank you. Bye-bye.